This way. Where are you? Yeah, the bid. COVID. Not deal with city.
Hey, should I submit my hotel bill or not?
Just make sure they're talking to the main thing.
Yeah, I am track card.
See, this is gonna go away.
Got it.
It's too hard to see that the battery's there. You can't see the battery if it's green. You can see the green light. See, like I said, don't touch that.
Oh.
That's what I'm saying. We had it at the perfect tension that you can raise and lower. And
Sorry.
people tend to do that. I was like, don't touch that because
Okay.
now it's gonna.
Okay.
Hey, obviously. Wagging
Don't
the
be alarmed.
rabbit.
Yeah, it's just whatever. That's the big.
I'll be very sweet when I speak in favor of Danny's resolution. I like getting on this.
And then we'll just. So. Thanks. Oh, that's too bad.
Get this.
You're right. It's like my way to like, I'm not eating it all day. Yeah. I know that this. But I'm happy to have two. Yeah. I'm in.
You look good at that.
Actually, yeah, no, I read it. Okay, I read it. You just had very. Yeah, I mean, I did just have very. Yeah, good. Thank you. Oh, no. Nobody's gonna talk after that. So like for the first 15 minutes, that might. I did. When people. But when you see afterwards. They do that. People are supposed to. Put this on, I put this on. Instead, just because they don't know, and rather than have this one, we can go here, they can go there, so just know that that might happen. And then when people are supposed to be going, sometimes they go. Love it. Very much. We have. I go with their needs.
Probably like. I'm not. I know. Well, I think it's like, you know, it's like a second share. They might do that. I don't think they like it. No. Only like a light second. But they don't have somebody else. They don't vote. Right. I said, here. Then some more. Except issue is that they get their status via their office, right? Not from. It doesn't affect theirs. 100% self. They are, every delegate gets, no, non-voting delegate. Oh, yeah. Unmotivated delegate is a member already. You get a speech, you can join the debate, You can participate.
Thank you. I just tried to refresh and take it out loud. Came on.
Okay, you have a word. That's what I thought. Okay. That's just, right, that's just, okay. That's a good number. Yeah, let's take a one. Okay. Do that.
So far, she's only six. Yeah, and then I mean, it's important. Right, yeah.
Good.
Oh, yes. Oh, yeah. Oh, my gosh. Oh, my gosh. Oh, yeah.
It does mine though. Yeah. Yeah, believe me. You want to drive it up. So. Looked at him and I said, hey, why? No, it changed in the house. Never mind. That was brown suit. Sure was kind of. Oh, yeah. Yeah. Not too long. Yeah, my wife really, I always thought I was. It's kind of fun. I bet you're confused. Anyway, so out. It is possible for you to.
You know, it's no. No, I. Oh, yeah.
Well, yeah. 106. Yeah.
I was, another hour, yeah. I'm almost always having them.
That's all of it. That's all.
I don't know why. Just different. I'm like, what?
Really fun. We are getting. Oh, wow. Yeah. All right. So, did all the, not a fun. Yeah. But.
Pretty good. Give it a couple hours.
I'm sure everything was great.
Actually,
4 years ago. Right.
I just want to ask you a question.
End of the day, do you want me to text you like water or a drink or anything, or can I bring your food up here? Do I not just everything? Well, it's better for me to know now, so I don't start blowing you up.
How about you?
But you could have people around you too. Yeah, I mean, there's water up here.
Okay.
Because I have my, and if it gets too close, I'll find you a binder. Okay, good. Got everything else you need?
Yeah.
Yeah, go ahead and get the resolutions now. Go ahead and get it here now.
I don't have any here.
How you doing?
Yep. This is against Wi-Fi.
Right.
Well, no, I focus on it.
Oh, I see.
We were just saying, if we're busy.
What are you watching? Oh, you're not watching anything. How are you? Good to see you. Things going okay? As well as can be expected.
How much, you know, it's pretty dark. I said, I gave almost half. Yes. That's majority. That's what people think. Not on the internet. That's right. Yeah. So.
That was easy, huh? I would just get the hard, you know what I'm saying?
You sure?
Yeah.
It's funny, I'm saying. Thank you so much for joining us, Laura.
Nobody like.
Section,
Oh. Yeah.
a little bit of all. I have a little. Yeah, I can't believe it. Yeah.
Oh, yeah, yeah. Anyway,
Yeah, that makes, just for a year, they were constantly is, more or less just. So, yeah, just that.
Just remember that.
No.
The way.
I know.
It's.
Birdie.
Present.
Hey.
No. Yes.
Yeah.
I was gonna say. bless your heart.
I know you gotta go work.
Hey.
Say hi. I know you're so busy these days. Mr. High Security Fund behind. Thank you. First one meeting. So I'll have to take her out.
The way that you interviewed yesterday. Yes, what am I saying? It was the majority. Majority consent, voting. Because abstaining is not voting. It's exactly, gotcha. Okay, yeah. Right, you know what I'm saying? There's a whole. I noticed you don't have a. Like in the. Oh, if somebody calls up. Nobody says. And we do immediately stop it.
Yeah, it's a point of order.
Yeah. That's a point of order, and they would do it from the random,
They would do it from the.
other memo, other.
Motions, other mics, they can call it.
And, if not, I can just say that I have a worker. If they heard that from like the pro, I would just say, that's not a. But the other things I would say, that's not a worker. Yeah, like if you're in a circle and then they're like, I wanna make very clear motion about that. That doesn't for everyone who loves to watch me eat. I'm gonna take them. As far as I know, she's even in person. But Sarah. Right. Oh, I used to take off my things about rostrums for my finish. This is. You know, we weren't that one. I like. How are you? Good.
Yeah, Norwood Place, like second row.
John. He doesn't.
Look inside their binder. I just want to check the most up to date. Okay, this is the one. Oh, yeah. You would, no, if you want it. I'll have you do markers. The other ones that have color. I just had an extra set, but it wasn't.
See how quickly we forget.
Public. There's no.
But it's green. It's not mine. Okay, that's the.
I just said beat it.
Okay, just go ahead and do it. Get my glasses out. Yeah. So true.
Well, no.
Yeah, actually.
Good. For the day. Are we- In Canadian.
Like I have stickers. I have this for your med.
Okay.
What do you want there?
How you doing? Oh, I'm gonna be around tomorrow. 19 days. I mean, it's like, well, I can see it. Maybe. You're, I think. I've been on some. In the Yucatan, and we're around the world. We go on to, those are when I go down there, I like, basically. Yeah. Yeah. Want to go see all the somebody. Anyway, I guess what's been going on today. So, they said, real guys, my way is haven't been inside. He says there's one stuff in red, 600, both smaller. It's been on the market. And I was just so then I got to take like for this. Right. 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 You know, but
I know.
Well, there you go.
I have really, he's like, I really, everything I think, I really like. Oh, no, that's really like the word. This is like.
Yeah. Obviously, 24.
There was one that looks like the, changes. Like everything we did.
Yeah.
2024 thing is over.
Yeah, those ones are okay. Those are couple.
That one.
Yeah.
Thank you, Larry.
That way. Yeah, I know. I'm, did you imagine that?
Okay, I have one more question. Does adoption by consent have?
It's the case, I think, but I don't think it really is the research.
I was like, was the one changing from like to see when?
Yeah. Big deal.
Feels like maybe it could be.
I mean, it's up to the chair, right?
So I can, I.
Yeah, try it.
Okay.
Yeah.
I mean,
Especially if you don't have any candidates.
like, what would you be?
Yeah.
Right.
Yeah.
So I can just kind of like.
That was
Maybe I have,
Yeah.
I don't think that's necessarily. Yeah.
I will.
Yeah, yeah, and I thought I was.
But.
It's not 6 votes, but.
I feel like.
Right? Oh, no, that's it. Oh.
Yes, yeah, that's why. We should avoid lawsuits, but.
Good morning. I am Maya Kehoe. I'm president of the Oregon State Bar. It will be my pleasure to call the 2025 meeting of the Oregon State Bar House of Delegates to order in just a few minutes. First, however, I'd like to go over the procedures for our meeting today, which I hope will give some time for anyone having additional technical issues to resolve them. I know that most of us now are accustomed to the Zoom platform and its features. Nonetheless, I ask that you bear with us and each other as we move through a detailed agenda and address any technical issues that may arise. Here to help me are the bar's Chief Executive Officer, Helen Hirschbiel, and our General Counsel, Ankur Doshi. We will be using Zoom to present reports and discuss the resolutions before us. We will be using the special House of Delegates voting dashboard to display resolutions and vote on them. I will give you instructions on how to use the voting site before we take our first action item. Right now, I would like to go over how we will be using Zoom. Perhaps the most important thing to know is that all of you can see and hear me and our other presenters, but if you are participating by Zoom, we cannot see or hear you until I officially recognize you and our tech team makes you a panelist in Zoom. We will use an online queue to manage debate on the resolutions. More on that in a moment. If you need to be recognized to second a motion, you will need to raise your hand if you're in person or in Zoom. You can do that in Zoom by clicking or tapping on the hand icon at the bottom of the Zoom window. If you are on Zoom and are recognized, we will enable your microphone so that you may speak. We will not, however, enable your video for purposes of making a second. Whether on Zoom or in person, please state your name and the region you represent or your ex officio status for the record. Please note that we have disabled the chat feature in Zoom. That's because all of our proceedings need to be on the record and open to the public, some of whom are following us on YouTube now. If you have technical issues at any time during the meeting, please call the support team at the OSB at 503-620-0222 and choose option 2 and then option 5, or send an email to hod@osbar.org. That's HOD@OSBAR.org. Once I call the meeting to order, we will proceed with the President's report, followed by Chief Justice Flynn's report on the state of the courts, then Budget and Finance Chair Megan Houlihan's report on the bar's finances. After the reports, I will walk you through our voting procedures and give you an overview of our parliamentary procedures. One final note before we begin the meeting. Your meeting materials include a brief report on last year's HOD action items. We established this as a regular report to the HOD last year, and we hope you find it helpful. No one will be speaking on that item. It's a written report only. It includes updates on last year's HOD resolutions, on amending the HOD rules of procedure, amending rules of professional conduct, and the bar's support for adequate funding for legal services, the Oregon Judicial Branch, and Oregon's CASA network. The report includes links to further information on both of those 2024 HOD action reports. On 2024 HOD action items, and we also have included a link on the page for resolution reports. I encourage all of you to review these new engagement features on the website. So let's begin. I will now call the meeting to order. Although the first action item for today is adoption of the final meeting agenda, I'd like instead to begin with our preliminary reports and presentations that will give some extra time to resolve any technical issues and for delegates to log into the voting website. If any delegates have not yet logged into that site, please do so now. Note that logging in is an additional step beyond just creating an account. There was some confusion about this last year because you can be on the site and still not logged in. To confirm you are logged in, please look at the top right corner of the site page. If it says log out, then you're okay. If it says log in, click there to go to the login page and enter the email and password you used to complete the credentialing form. If you need assistance, raise your hand if you're in the room, or if you're on Zoom, please email hod@osbar.org for staff assistance, or call 503-620-0222, option 2, and then option 5. I will start with my report as your 2025 OSB president. Thank you again for being here today and for your leadership as a member of this body. The Oregon State Bar depends on the hundreds of volunteers that dedicate their time and wisdom to advance our public service mission. You are a vital part of that work. Thank you also to Chief Justice Flynn and your colleagues on the Oregon Supreme Court for the remarkable work that all of you do. I also want to note how much I appreciate the strong partnership we've established and nurtured over many years. It's really something special. I have a few short updates on key initiatives of recent years. In our access to justice work, I'm pleased to report that after welcoming our first licensed paralegals into the Oregon State Bar last year, we now have 28 LPs actively serving clients in both family and landlord-tenant law. And we have 3 additional LPs in the pipeline and awaiting test results. We also now offer the Supervised Practice Portfolio Examination for admission to the bar. This is an apprenticeship plus the Board of Bar Examiners examination of legal work product for admission. As of this week, we have 36 SPPE applicants that have successfully completed the portfolio exam and are newly licensed to practice law. An additional 156 SPPP applicants are working through the program, and 213 supervisors and 179 law firms, our employers, are actively seeking to hire or have hired SPPPE applicants. Still in the access to justice arena, it's been a remarkable year of growth for Oregon Law Help, the interactive website offering Oregonians a single point of access for legal help and information. It launched in 2024 with just 2 primary areas of law covered: family law and housing law. It has now comprehensive content in 15 areas of law in multiple languages and continues to grow as a resource for those struggling to access legal help. If you have not already, I encourage you to check it out. It's been a very big lift, and it's an impressive tool in our access to justice arsenal. In big picture work, we've been working through an extensive 5-year strategic planning process this year. One early step in the process was adoption of our values, a process that looked intentionally at how each value connects directly to our mission. You can find details on those connections in the OSB values document and the resources page on the HOD platform. But the Oregon State Bar's values include diversity, equity, inclusion, justice, well-being, transparency, humility, compassion, and innovation. We also approved our strategic priorities and a more sophisticated planning tool to help staff evaluate and prioritize their work and maintain its alignment with our statutory functions and our mission. The 5-year plan, which of course will be adapted in real time as necessary, will be presented to the board in November. In the interest of time, I won't elaborate here, but it's been a very deeply meaningful process, and I'm really proud of the intentional way we're planning for the future. Finally, I'd like to share some thoughts about OSB Board of Governors, past and present. I would surmise that every lawyer who serves on the BOG at some point during their first year thinks as I did. I honestly had no idea how much this bar does. It is remarkable, and even as one who has been actively involved in the bar since law school, I had no idea. And our staff and the support that they provide to those services is outstanding. My own practice takes advantage of numerous programs afforded to me through the OSB licensure. These range from practical things like no-cost access to legal research tools, to professional development, support through sections and CLEs that make me a better lawyer, to more big picture leadership through the law improvement program and through engagement on crises like our public defense challenges, the alarming rates of mental health and substance abuse among practitioners, and the lack of legal professionals in rural Oregon. I'm perhaps most proud of our position as a nationally recognized leader in bold action to address the needs of Oregonians. This bar and the court recognize that the legal profession must adapt to changing times and are not afraid of carefully crafted innovations to maximize our impact on the public that we serve. Innovations like the LP and SPPE programs don't happen without deep thought and engagement with smart leaders who will act with conviction and courage. I couldn't be more proud of this board, this court, the staff, and of the legal professionals like all of you who keep pushing for creativity and impact in the most important work. Thank you. Now it's my pleasure to introduce Chief Justice Megan Flynn of the Oregon Supreme Court, who is here to present an address on the state of Oregon's courts.
You ever have those mental gaps where you can't remember the password to your iPad? Okay, I'm going to do it very carefully, otherwise it's going to lock me out. Okay. Morning. Thank you. Thank you to all the folks up here. Thank you to all of you Thanks. I'm grateful for the opportunity to be invited to talk today about the work of the state courts on behalf of Oregon's judicial branch. Is it not on? Do I do this? No, that's up and down.
Get right up close to that microphone.
Hello, is that it? Okay. Morning, thank you. On behalf of Oregon's judicial branch, I want to thank can you hear me? The bar for our partnership and for all that we've been able to do together and continue to do together to ensure that court users receive fair and accessible justice services in our courts. As I report on the state courts, I'm going to start with the results of our 2025 legislative session, which is how I at least spend a substantial portion of my last year. And I want to thank bar leaders and all of you for the help that you gave us on our budget this past session. We didn't get everything we wanted, but we were maintained 100% of our existing current service level. And we had some additional funding for future, for improvements in areas that are priorities, especially in relation to our ongoing justice campaign. With your help and support, we emerged from this session with many significant needs addressed in whole or at least in part. One of the highlights is courthouse security. We have an ongoing need in many of our courthouses for some form of entrance screening. We thought we had an idea for a pilot project to use state-supported entrance screening and thus be less dependent on the counties. The legislatures emphasized that they understood that need. They just were not excited about that approach, but they did invite us to come back more creatively in the future. But significantly, they gave us $2 million to use as grants to develop security. And we think that we're going to be, with county support from a number of these counties, able to, 5 new counties are going to be able to have full-time entrance screening. They also finally gave us a meaningful adjustment to judicial compensation. Again, that's something that the bar, all of you are providing tremendous support for that for as many sessions as I can remember. It finally happened. There'll be a 10% salary increase for judges. There was in July 1 of 2025, and there'll be another 10% in July 1 of 2027. So that's really is a big deal. We also were given new judicial positions, circuit court judges, and then related staff positions so that you're not just getting a judge and tapping the staff more significantly in Clackamas, Douglas, and Lane. And then they did not give us positions we'd asked for in Crook Jefferson counties and Umatilla Morrow, but those counties continue then to be on our list of priorities as we continue to work for adequate judicial staffing around the state. They also gave us a little bit of additional court staffing, mostly related to supervisory positions and positions in court statewide that help manage the challenges of the unrepresented persons in the criminal justice system. Court facilities, some good news locally. We on $1.25 million for the Washington County to start planning their new courthouse, and $2.5 million for Morrow to finish their courthouse. So those are great. And then a little bit of money for ongoing projects in counties like Harney, Hood River, and Umatilla. Then there's also a number of bills that affect the courts that the legislature gave us this session in terms of training and education. That's probably for judges, that's probably one of the biggest one. There's 2 different bills that make a difference. Senate Bill 710 is a legislative directive related to required training for judges on trauma-informed judging practices, some CLE requirements and things like that we're developing right now. And then the other interesting one, House Bill 2712, is direction to create an ombuds office for individuals to address concerns they are having about their courthouse experience. So between them, they kind of create this unique opportunity for us to really have the positions to focus on improved judicial education and training. We're going to stand up mentoring and coaching process for judges that'll be available both through concerns that come through to us in the ombuds process, but then also just for any judge who wants to improve their courtroom manner or dealing with certain kinds of challenges, that type of thing. So we're really excited, moving very quickly on that. And there's a lot of excitement among most of our judges. Another thing that affects the courts relates to behavioral health. There was a collection of bills. Probably the most significant for us is House Bill 2005, modified the standards and procedures for civil commitments, codified some of the timelines that have been in operation under a federal order related to those who can't aid and assist in their defense. But then there's also some investment that is going to be very helpful with the behavioral health residential placements and with additional funding for community mental health to aid the transitions between state hospital placements and community placements. There's a House Bill 2492 modified the process for setting aside convictions, includes contempt findings as eligible to be set aside. So that's significant. In civil law area, Senate Bill 690 directs courts to reschedule eviction hearings in certain cases involving very young children under 1 year of age, who are eligible for state housing supports. So we'll see how that plays out. House Bill 2461 allows, and this is the BAR's bill that we were fully backing, allows parties to request remote location testimony, and it changed it from a fixed kind of unrealistic time in advance to sufficiently in advance. So we're hoping that's actually going to just catch up with a lot of practices anyways, but that should make things a little more simple. I want to thank the many people who contributed to our work this session, including many of you here today. Your voices really made a difference. While we weren't able to secure all the resource we'd requested as courts, the reality is that this was it was a tough budget session. A lot of entities lost funding, and we're very happy the judicial branch came out a little better able to do our work. And then there was a recent bar bulletin that I wrote an article thanking the attorneys and legal practitioners who devote so much time to making committee work for the judicial branch a reality and allow us to do our work and serve the public. I also want to thank all of you who've supported and are supporting the supervised practice portfolio examination. For new lawyers, my court has continued to admit folks every time. We had the most recent swearing in just a couple weeks ago. It seems to be really a meaningful and successful program. And then also, very much thank you for your support for the Rural Practice Initiative. Those grants have allowed law students from Oregon's 3 law schools to spend a summer as an extern in rural courts. This next summer, you're going to help us expand it to even more students being exposed. I had lunch recently with the 3 who did it last summer, and they had a fantastic experience. Even if they don't personally go practice in a rural area, they're telling everyone in their circles the advantages they saw about doing that. So I think it was an inspired suggestion, and we're so happy to be a part of that. A few more highlights from the past year. We implemented a statewide centralized service for child support cases and regional approaches for family law facilitation that should make those a little more available in the more smaller courts. In December 2024, so a little over a year ago, we completed the automated, I guess it's not over a year ago. We completed the automated sealing of 47,000 eviction cases. And so we're very proud of that. We're still kind of working through some other remaining backlog. We've made improvements to court monitoring of guardianships and conservatorships, if any of you are in that area. We are doing our best to manage the Spanish language interpreter shortage, and we're deploying a statewide pretrial system that supports public safety, protects defendant rights, and bolsters appearance rates. We also continue to collaborate with the bar and legal aid and others on the Oregon Law Help, which President Kehoe described, and that's another very exciting project for our justice system. But I feel like this of the court's report is not complete without addressing a fundamental priority on which the bar and bench must continue to focus, and that is preserving the rule of law. Our shared commitment to equal justice under the law requires us to maintain and defend the vital role of the judicial branch and the integrity of our judicial facilities and processes. People have long criticized judges and lawyers when they've disagreed with the outcome of a case, but the increased frequency and personal attacks and even physical violence requires unusual vigilance. It's existentially threatening when the constitutional role and authority of the courts, as one of the three pillars of our democratic system, are called into question. Our democracy depends on checks and balances of co-equal legislative, executive, and judicial branches. It's been a key part of our ability to endure as a nation. In our state, our executive and legislative branches deeply appreciate and respect that separation of powers. But as and if that respect erodes nationally, it affects us all as well. So as we continue to navigate the attacks on judges and lawyers who are simply upholding their oaths, the oaths that we have sworn to uphold the Constitution and laws of the United States and the state of Oregon, I'm more grateful than ever for your shared commitment with us and your strong voices in support of the rule of law. So thank you.
Thank you, Chief Justice Flynn, for taking the time to address the House of Delegates today. Our next agenda item is the report. Our next agenda item is the report of the Board of Governors Budget and Finance Committee and notice of 2025 annual fees. For that, let's welcome Megan Houlihan, Committee Chair and Board Member from Region 5, who is joining us today via Zoom.
Thank you, President Kehoe. Good morning. I'm Meg Houlihan, the Chair of the Board of Governors Budget and Finance Committee. Thank you for joining us today. I'm here to provide a brief report about the 2025 financials and 2026 budget, as well as an early look at what lies ahead. Last year, we projected that a combination of lower inflation and higher interest rates would help stabilize some of the inflationary pressures on the OSB budget. Unfortunately, tariffs and other underlying economic factors have continued to keep inflation higher than many experts predicted. There are some signs this is finally improving, but inflation remains higher than we would have hoped. Other expense side pressures included an increase in staffing costs, largely due to the rising cost of benefits and some wage pressures to fill open positions. On a positive note—
One second, Meg. We can't hear you very well. Hold on one second. Okay, try now.
Can you hear me better now?
Yes.
Okay, thank you. On a positive note, program expenses are well below budget, and we expect to end the year with operating expenses approximately $284,000 under budget. On the other side of the ledger, revenue from general licensing fees in 2025 is forecasted to end the year slightly below budget, while revenue from programs, items like CLE attendance, conference room rentals, and bulletin advertising is slightly higher than expected. We currently forecast ending the year to be about $38,000 ahead of budget and revenue. This translates to a forecasted net cash position $322,000 above projections and an overall forecast to end 2025 under budget. I'm happy to report that forecasted net cash position I'm happy to report that we are on sound financial footing and are not seeking a licensee fee increase for 2026. However, it is likely that we will need an adjustment in 2027. I'd like to shift briefly to some longer-term context. Historically, licensee fees make up 2/3 of the bar's total revenue. This has allowed the bar to generally maintain a steady operational budget as the number of new licensees coming in kept pace with more senior lawyers retiring or otherwise leaving the profession. That stability has allowed Oregon to be a leader in offering licensees a high-value menu of programs to support their practices and serve the public. Services like full access to all of the bar's legal treatises and bar books, which licensees used to have to purchase separately, subsidized access to legal research tools like Decisis, or formerly Fastcase, and programs like the Loan Repayment Assistance Program to support recruitment to rural, government, and nonprofit legal employers. These are all examples of benefits that Oregon has been able to offer legal professionals in support of our mission. However, this trend of new licensees balancing out retiring licensees is shifting as population ages. We currently have 2,200 active licensees above the age of 67, approximately 14% of our active practitioners. At the same time, we have 454 legal practitioners who are under 30 years old, suggesting that retirees will soon outpace new licensees. In short, the basic formula that underlies our long-term financial planning is shifting. We are not alone in this, as other professions face similar demographic movements. The Board of Governors is looking deeply at these shifts and is committed to staying ahead of this trend. Our strategic planning is focused on closely monitoring and controlling program and operational costs, pursuing efforts to generate additional revenue, and ensuring that all our work is closely aligned with the bar's public service mission. I invite anyone who is interested in further detail to reach out to me or any committee member with further questions. The Budget and Finance Committee is thankful for the hard work and dedication of the management team and all the bar's employees who continue to use every dollar wisely and to further the mission of the bar. Thank you for your time and consideration.
Thank you, Ms. Houlihan. That concludes our reports for the day. Now I will explain how our discussions will proceed from here in the room and in the Zoom webinar, and how we will use our voting platform. This is another opportunity to be sure you are logged in. In the top right corner of your screen, it should say log out. If it says log in, then you should click there and log in with the email address and password you used when you completed the credential form. If you need help, please raise your hand if you're in the room. Or if you're on Zoom, send an email to hod@osbar.org, that's hod@osbar.org, or call 503-620-0222, press option 2 and then option 5. Staff will make the resolution sponsors who are participating on Zoom panelists so that you can see and hear them. At the same time, we will also bring on screen our green light, yellow light, red light timer. Sponsors of each resolution will have 5 minutes to present them. We'll count down like we always have. Green, you're good to go. Yellow, please wrap it up. Red, stop. We will be reasonable if you need to finish your sentence, but please be respectful of the time limits. If you go over your time, your mic will be muted. At the conclusion of each presentation, the sponsor or one of the sponsors, if there are more than one, will move adoption of the resolution. I will then ask for a second. Any delegate wishing to second the motion should raise their hand, as we discussed at the beginning of the meeting. Once a resolution has been moved and seconded, debate will begin. All remarks should be directed to the chair. To speak on a resolution, you must reserve a spot using the online voting platform. I will ask for everyone, those in person and on Zoom, who wish to speak on a resolution to reserve a speaking spot on the voting platform. Select a category for your position and then indicate whether you're in person or remote. A virtual line will be made for pro, con, or motion/questions speakers. I will call on each person in the order submissions were received, alternating between the 3 lines. For those of you searching for the debate queue right now, it's not there. You will not see the debate queue until there's a motion and a second and staff has made the debate queue live. Please note that motions such as a motion to amend or motion to end debate must be made from the motion/questions queue. HOD Rule of Procedure 7.7 provides that motions from the floor or from the pro or con queues are out of order and will not be recognized. If I call your name from the debate queue and you're on Zoom, staff will allow you to unmute your microphone and enable your video camera. You will see your Zoom screen momentarily disconnect and reconnect when staff enable your participation. This transition can take a few moments. Please be patient and use that time to take a deep breath. If you are present in the room today, please be prepared to stand at the microphone in the room when your name is called. Please state for the record your name and the HOD region you represent or the basis of your ex officio status. This is important anytime that you speak today. Our proceedings are being stenographically recorded as well as audio and video recorded. Our court reporter today is Holly Goodwin, a member of the Oregon Court Reporters Association. Please accept my thanks on behalf of the House of Delegates and the entire bar membership for your work today. Speakers from the floor have 3 minutes each. Keep an eye on the timer. After you have spoken, staff will remove your name from the queue and I will choose the next person to speak. We will proceed to recognize speakers from pro, con, and other queues in the same order until all speakers have been recognized or there has been a successful motion to end debate. Proceedings today will follow the HOD Rules of Procedure and Robert's Rules of Order. On the voting site, under the Resources tab, if you select Overview of Procedure for House of Delegates meeting, you will see written information are the parliamentarian procedures. Scroll down the page and you will find a chart showing the respective priority of common motions. If you want to make a motion, be aware of where it is on that chart and, again, which queue you're entering. At this time, I'll ask you to welcome our parliamentarian for today, Lori Brocker. She is here to help with any procedural rulings today. Please also turn to the HOD 2025 voting platform now. Thank you, Lori, for your pro bono service to the House of Delegates. Along with resources for delegates, this is also the platform where you can review resolutions, where we will post any amendments, and where you will vote. I will review those procedures now. If you're not already on the resolutions page, please click the word resolutions on the banner at the top of your screen. On the left side of your screen, you will see tabs for all of the resolutions on our agenda. You can see the text of any resolution by clicking on it. If there is a motion to amend, the amendment text will be shown on this page as well. For delegates moving an amendment, please email the amendment language to amend@osbar.org. That's amend@osbar.org, clearly denoting your name, region, and the amended language with the resolution. Council will review the amendment to make sure it's in order before passing it to staff to present in the voting platform. Once the motion to amend receives a second, staff will update the voting platform to show the amended language and start debate on the amendment. We will need to pause debate briefly for this process. You will then need to hit the refresh button to see the new text, but don't worry, I will remind you. All amendments except those that involve the addition or deletion of a single word must be emailed to amend@osbar.org to ensure that we accurately capture the text of the amendment. When I call for a vote, refresh the page to see your voting options. Choose yes if you support the resolution, no if you oppose the resolution, or abstain if you prefer not to vote. Click the button to submit your vote. Please note that once you submit your vote, it is final. You cannot go back and change it. Once you have voted, you will be redirected to a results page, which you can refresh to update the results. The names of the delegates will be displayed in separate columns, indicating how each delegate voted, and a pie chart will show the percentages of yes and no votes. When voting is complete, I will announce the results and move to the next resolution. You should also keep in mind that this is a public meeting and the results on this website can be viewed by the public. For each resolution, amendment, and other motion, we will vote in the same manner, review the results, and return to the resolutions page for the next step. I will guide you through the process each time we have a vote. For now, and for practice, we're going to use the voting system to establish quorum. If you could please click on the Quorum Call tab, please select the option that indicates you are present and ready to vote. If you are not logged in or have trouble accessing the Quorum Call page, please raise your hand, send an email to hod@osbar.org, or call 503-620-0222, option 2, and then option 5 for staff assistance. You may need to hit your refresh page. Just in case you need those instructions again, you're going to hit the Quorum Call tab and then select the option that indicates you are present and ready to vote. And if you don't see the Quorum Call button up in the upper right corner, it should say refresh page, and you click that button and it will refresh it for you. Redo it. Okay. Thank you. We have a quorum. Okay, now we're moving on to adoption of the agenda. Now, if there is a delegate who would like to make a motion to approve the meeting agenda, please raise your hand now. Okay, I recognize David Wade. Can you please state your name and voting capacity? Okay, and that was David Wade, Region 2. Thank you. If there is a delegate who would like to second the motion, please raise your hand. And I see John Bachhoffner. Can you please state your name and ex officio status? Okay, and that was John Bachhoffner, out-of-state delegate, that seconded the motion. Are there any objections, or is anyone seeking to discuss the motion? If yes, please raise your hand now so we can open the floor for both debate and a vote. Okay, hearing no objections, the motion to adopt the preliminary agenda passes by unanimous consent. Okay, now back to the resolutions page. Our next item of business is BOG Resolution number 1, which will be presented by Ankur Doshi, General Counsel.
Thank you, Maya, for the introduction. Good morning. I'm Ankur Doshi. I'm General Counsel for the Bar, and I'm here to introduce the first resolution by the Board of Governors to the House of Delegates. The Board of Governors seeks adoption of Board Resolution number 1, which provides several amendments to the House of Delegates Rules of Procedure. These amendments are not substantive amendments to the Rules of Procedures. Instead, these amendments seek to align the Rules of Procedure with the changes pending with the Bar Act for 2026. The legislature passed SB 166 earlier this year, which changed the terminology utilized in the Bar Act, ORS Chapter 9, from member to licensee. This change was conducted to show the bar's function as a regulator to those licensed to practice law. The bar has undergone a number of changes similar to this change in its rules and relation in the passage of SB 166. This change is similar in nature. HOD Rule of Procedure 11.1 requires any amendments to be adopted by the House of Delegates. This board urges the passage of resolution number 1 to go into effect on January 1st, 2026.
Do we have a motion from one of our BOG members? Okay, let's see, Elizabeth Inayoshi. Can you please state your name and voting capacity? Okay, and that was Elizabeth Inayoshi, who's the Board of Governors delegate from Region 5. Thank you. Is there a delegate who would like to second the motion? Okay, Kyle Shiketti, please raise your hand and state your name and voting capacity. Okay, and that was Kyle Shiketti from Region 8 for the Board of Governors. Now for discussion. Okay, the debate queue is ready. If you want to speak on the motion, click the debate queue button, indicate your position and location, and click submit. Okay, with no further discussion, we will proceed to vote on BOG Resolution number 1. Please give staff a moment to ready the vote. Okay, voting is now open. Please turn to the resolutions page of your HOD voting dashboard. Hit the refresh button, which is the refresh page button in the upper right corner. Indicate your vote. Yes, if you support the resolution, no if you oppose it, and abstain if you prefer not to vote. Again, your vote is final once you submit it. You have 1 minute to vote. Please start the timer. You have 30 seconds. Voting will close in 5 seconds. Please close the voting. We will now tally the votes. Okay, the voting results are ready. You can hit the refresh results button to see the voting results. The number of yes votes was 150. The number of no votes was 2. The number of delegates who abstain are 2. So the motion passes. Moving on to BOG Resolution Number 2, Ankur Doshi, OSB General Counsel, will present this resolution as well.
Thank you again, Maya. In my capacity as General Counsel, I also serve as Bar Staff Liaison to the Legal Ethics Committee. The Board of Governors have proposed, upon the recommendation of the Legal Ethics Committee, the adoption of Resolution Number 2, which seeks to amend Rules of Professional Conduct 1.5 and 1.15. These amendments propose a focused modernization of our fee rules with 2 aims: to improve client understanding of advance payments and to reduce disputes about when and how unearned fees are refunded. The approach relies on plain language and a short disclosure rather than major structural changes as to how lawyers bill for services. Currently, Rule of Professional Conduct 1.5 uses language earned on receipt or non-refundable for fixed fees. Fixed fees provide legal services at a set cost to the client. The fee is not kept in the lawyer's trust account, but placed in the lawyer's operating account. Paradoxically, fixed fees, even though denoted as non-refundable under RPC 1.5, are still refundable if a fee is unearned. The ABA Modern Rules and ABA Formal Opinion 505 has strongly disfavored the use of language such as earned on receipt and non-refundable, noting that it simply sidesteps an attorney's ethical obligation in relation to refunding fees and misleads clients. In 2022, the Client Security Fund requested that the Legal Ethics Committee review the language utilized in RPC 1.5C3. The Client Security Fund noted that approximately 25% of the claims paid through the fund were for the failure to refund unearned fixed fees. The Client Security Fund Committee noted that the use of the term non-refundable and earned on receipt discouraged many clients from seeking a refund from their counsel. In reviewing the proposal from the Client Security Fund, the Legal Ethics Committee assembled a group of stakeholders, including attorneys that utilize prepaid legal fees in immigration practice, criminal practice, and transactional practices to evaluate a change in the rules. This change was discussed over the past year and approved by the board in April of this year. This proposal does 2 core things. First, it prohibits the use of non-refundable and earned on receipt and instead adopts the plain English language term prepaid fee. Second, it requires a written fee agreement with simple and clear disclosures to the client. These disclosures cover 5 points important to the client's understanding of the representation: the scope of the work, the total price or pricing basis, that the prepaid fee would not be held in trust, and the client's right to terminate representation at any time, as well as the availability and method for calculating refund. These disclosures do not differ substantially from the currently required disclosures in 1.5C3, but makes expectations to the client explicit at the outset of the representation. The overall effect of this amendment would be modest but practical. The amendment would continue to allow prepaid flat fees, but would reinforce existing disclosures about the availability of a refund and supplies a checklist-style disclosure designed to reduce misunderstandings between the client and the attorney. The board would urge the House to adopt this resolution.
Do we have a motion from one of our BOG members? Okay. Mike Purcell from Region 2 has moved. And do we have a second to the motion? Okay, I recognize Simone. Will you please state your name and region? And that was Simone Wyand, Region 4 BOG member. Now for discussion. Please give staff a moment to prepare the debate queue. Okay, the debate queue is ready. If you want to speak on the motion, click the debate queue button. Indicate your position and your location and click submit. I recognize Shay Meehan from the Pro queue.
Shay Meehan with the House of Delegates Region 5. And I would urge people to vote in favor of this resolution. I think that it does address a language issue that does not make sense for clients. Having been revisited and taken part in this drafting, I think that it clearly accommodates those of us, including me, who use prepaid fixed fees as a standard part of our practice. I think that it will help to eliminate confusion and provide a good standard for practitioners, as well as providing necessary protections for clients. So again, I urge that people vote in favor of this resolution. Thank you.
Thank you. I now recognize Dean Alterman from the Con queue.
Good morning. Dean Alderman, delegate from Region 5. I think the draft solves the problem it's set out to do, but it creates another problem. It creates a new problem for a kind of fee that I don't believe the drafters considered, but which I have used very frequently in my practice. I have people who pay me retainers simply to be available to answer the phone for their calls where the fee has no relation whatever to how much work I do. The new draft appears to prohibit that sort of fee where I'm being paid simply for availability, where the fee is independent of the service or whether the people even want it, where it's simply to be available and not to be conflicted out. So I like the draft as far as it goes, but it creates a new problem, and I think it needs to be revised to solve that problem as well. Thank you.
Okay, thank you. I now recognize John Bachhoffner.
John Bachhoffner, out-of-state delegate. I have a question. I serve as an arbitrator and mediator solely now, no longer do private practice of law. Technically, my reading of the rule says a lawyer shall. It does not clarify in the course of legal services. So it seems logical that that's what it's meant to do, just for engagement for legal services, but I'm seeking some clarification on that issue, specifically so we create a record.
John, could you specify which issue which word you're looking for
Well,
clarification?
it says a lawyer shall. It does not say in the course of legal services. It says I'm a lawyer, and in my mediation and arbitration practice, I typically utilize a non-refundable deposit that applies to different administrative factors, and I apply my time against that. But if the matter resolves before arbitration or before the mediation, I've earned the entire amount. Am I now, as a mediator and arbitrator, not providing any legal services? Am I required now to incorporate the language and have the people who retain me for a mediation or arbitration sign it?
I think this addresses one issue, and as well as the issue that was raised in the con column earlier. Microphone? Okay. I think this addresses two particular issues. One that was addressed in the con column earlier, as well as this one, is the difference between a true retainer, which is a retainer that is made specifically to reserve an attorney's time, versus a prepaid legal fee, which is specifically a fee paid for a portion of services to be rendered. In your instance, what you're referring to is essentially the same as a true retainer, which is where a client pays an attorney a fixed amount to be available for any services. That is essentially a retainer that's paid for the opportunity cost that is lost by the attorney for utilizing those types of work. In your instance, I would think that would fall into that. The ABA has made that type of clear delineation between a prepaid fixed fee versus a retainer fee in the term of true retainer fees. To be circumspect, true retainer fees like that are not generally used as much in the normal course of business. So it is something that's not necessarily seen. Nowadays, the terminology retainer is primarily used just to denote any type of money that is given initially by the client for the purposes of service. It doesn't necessarily denote a purchase of the attorney's availability. However, in the past, that has been the case, that there has been a retainer that has been used to purchase the availability of that attorney for any matter, and that has been deemed okay by the ABA in its opinions in regards to prepaid fees.
What about the issue of whether or not it's the practice of law? I mean, you're saying the way it's written, it says a lawyer shall. I am a lawyer. Setting aside the retainer, and I may debate whether or not I see this as a retainer. Do you agree that does not apply to a lawyer who is not providing legal services?
I think part of that is that this does create, this area of the RPC specifically deals with lawyer and client relations. In your position as a mediator, I think that's somewhat outside the scope of that.
That's what I thought. Thank you very much.
McDaniel Reynolds.
My name is McDaniel Reynolds, representing Region 5, standing closer to the microphone. Thank you. I wanted to frankly thank the delegates and the Board of Governors and Anchor and everyone else who put work into this. I was not a member of this esteemed body last year, but I saw that the flat fee proposal was something that would have turned my practice on its head. And I was very, very concerned. I wrote to just about everybody here and expressed that. And I'm happy to say thank you for taking it off of last year's agenda, putting more thought into it. I would urge people to vote yes on the present version. I think it does add clarification for something that didn't make any sense for clients, but it allows people who use flat fees as part of their routine practice to continue to do that. Thank you.
Thank you. I now recognize Carl Mueller, who's remote.
Good morning. My concern is with the language on both that the fee will not be deposited into a trust account and that the client may be entitled to a refund and how any such refund will be calculated. So it's really two concerns. The first is if the lawyer has not earned the fee yet, why wouldn't it remain in the trust account? A. And then B, in terms of how any such refund would be calculated, forces a lot of people who use flat fees to then re-engineer the hourly fee in a way that I think undercuts the whole idea of a flat fee. That's all I have. Thank you.
Thank you. Okay, I now recognize Daniel Ling, who's in person.
Good morning. Danny Lang, Region 3, ex officio delegate as president of the Douglas County Bar Association. I have a concern. I understand that the goal of this amendment, but I see it creating a problem for a particular way of doing business that I have found to be wonderful for 4 decades, because I don't bill by the hour. The problem with billing by the hour is there's no limit. The client can run out of money before we run out of services. A little louder? Okay. By the way, I apologize for being late this morning. There was a crash on I-5 and we're running about 45 minutes late. But I will give you what I consider to be a workable method that I'm concerned this might infringe upon it. And I'm just going to use the hypothetical of someone who's arrested for DUI. Their car was towed, and they failed or refused a breath test. And then from the implied consent hearing, the attorney develops a series of motions to suppress, and some of those facts gained over working the case can also lead to pretrial or in-trial motions in limine and other motions, and then the trial itself if need be. So a package, a flat fee of X dollars. And it's not refundable in the sense that the goal is to handle from arrest through verdict and even through diversion after that, if that be the case. And it's difficult to try to piecemeal without trying to bill by the hour, because there are cases where the officer doesn't show up for the implied consent hearing, and that's a lot of work. I take those very seriously. They're a case within a case. So the officer doesn't show up, and you're out in 15 minutes with a coupon, the client is, to go back to DMV. And then maybe you take something you learned during the case, and you're successful with a motion. The fourth motion in limine, motion to suppress is successful. And then 48 hours before trial, the DA dismisses. So I'm concerned that this might create problems because the money goes in trust and is not paid out until all of those tasks are completed, a package, and the package is done. So I have to vote no.
Thank you, Danny.
Thank you.
Okay, I recognize Shay Mian. No,
Michael.
sorry.
So,
Michael Purcell. Shay, I can't recognize you yet since we have to let other people who haven't gone first. Okay, thanks.
Thank you and good morning to all. My name is Michael Purcell. I'm from District 2. That's Multnomah County, right? Wherever it is, that's where I'm from.
Region 5.
Region 5? Okay. I was on the Legal Assistance, Legal Ethics Committee for, I don't know, it seemed like many years. It was actually 3, and I was involved in drafting of this. I want to address some of the concerns that have been raised. We don't have in this proposal any statement about how you're going to do the refund. when you take on a flat fee, or really any fee, you have to be prepared in case the client does dismiss you with how you're going to calculate a refund. One way that one can do that, which was recently, would be to set up your fee agreement in a stage situation. I'm an immigration lawyer. Basically, an immigration lawyer, it's kind of complicated, but basically there's two phases. One is preparing the application, and the other is maybe attending an interview. Application could be 80% of the representation. So if you finish that, the fee fully earned would be 80%. When you get to the interview, that would be 100%. But you could set up your work in a stage situation where you got paid, 80% of the fee, and then later you would collect perhaps the other 20%, or you could put the 20% in trust. What if the trial doesn't happen, for example? That would be one way you could do that. I'm not going to pretend to tell people, how they would manage their practice, but you could individualize this and be, I would think, very helpful to earn, to establish what fees are due. I want to talk real briefly, though, about the client security fund. 25% of the dollars paid are for client for these kind of claims arising out of really a lot of them came from immigration lawyers, and that's my shame, but it's my concern anyway, because I know that area fairly well. But 66% of the claims, the actual number of claims, came from these earned on receipt fees. And a lot of times, and this I think was pointed out in the State versus Long case, a lot of these folks don't have $3,000, $4,000, $5,000 they can come up with to get a new lawyer. And I want to tell you, from an immigration point of view, I try not to be emotional about this, but people call me every day and they're afraid of what might happen to them. They need a lawyer and they don't have another $3,000, $4,000, or $5,000, which, as far as lawyers go, may not be a very big fee. But when some person that's not acting in the best interest, and I know everyone here is, and the vast majority of lawyers are, but one person, we saw this about 11 years ago, maybe 12 years ago, one person had 87 claims submitted to the Client Security Fund, at least, and there probably were more people. Anyway, please vote for it.
Thank you. I now recognize Theodore Reuter, who is remote.
Theodore Reuter, Region 4. Appreciate the opportunity to address the panel, and I want to ask a clarifying question. As I understand it, this particular statement that we have here is intended to replace the rule C 1.5C3. And so what we're dealing with here is a very specific class of situations where you have an attorney who has entered into an agreement to provide additional services and is accepting payment that will be deposited directly in their trust account rather than depositing it not directly into their trust account, directly into their operating account, or taking possession of it in some other way rather than depositing in their trust account. So as I understand it, that means this rule does not apply to situations where one is charging a fixed fee but is not going to take that money into their possession until after the services is complete. It does not apply to a true retainer because what you're actually paying for is availability rather than services. And it would not apply to the standard situation where you're billing on an hourly rate. So it seems to me that some of the concerns that are being raised on the con side don't fit directly into that category. Am I properly understanding what this rule is intended to address, or is there another category that I'm missing?
No, Ted, I think you're correct in your understanding of it.
Okay, thank you.
Okay, I now recognize John Grant, who is also remote.
Hi, everyone. John Grant, HUD member, Region 5. Thanks for the opportunity, and I'll be brief. I just want to sort of echo what Michael Purcell said in terms of the concern around how, and sorry, I'm looking over here at the language, the method which any refund would be calculated. For those of you who don't know me, I do consulting work with a lot of small law practices. I have lots of clients that utilize flat fees. And far and away, the most common way to calculate refunding of flat fees has to do with either project deliverables or milestones with respect to the legal matter. It does not involve having to back in an hourly rate calculation into the flat fee discussion. So I just wanted to address that head on. I also wanted to just give you a point of reference. I have a client in Maryland. Maryland recently enacted a version of this, but actually requires that all flat fees go into an IOLTA account. And as a result of that, this particular firm, which had been offering flat fee debt defense services as sort of an access to justice program within the firm, are reevaluating the economic viability because this firm doesn't otherwise do IOLTA accounting. They haven't had to have a trust account in the past. They're now required under the new Maryland rule to use trust accounting, and it's causing them to question whether this particular access to justice line of practice is something that is feasible for them to carry forward with. So those are my comments. Thank you.
Thank you. I now recognize Shay Meehan again.
Thank you. Thank you very much. Shay Meehan, Region 5, again, wanting to respond to a couple of things I've heard against this resolution. One, I was not on the LAC, but did serve on the subcommittee that worked on the drafting of this. And pure retainers were actually discussed in the course of that drafting. And I see nothing in this rule that prevents a pure retainer arrangement, provided that the explanation of what refund, if any, would be granted in the event that arrangement is canceled is spelled out clearly. And I think part of what we're seeing here is the convergence of the issue of prepaid fees versus what's a reasonable fee. And no matter what we do in the rule about prepaid fees, fees still have to be reasonable. I'd also point out that this does not actually require us to go back to a hidden hourly practice. I've certainly, in the course of this, explored a lot of different ideas about how refunds might be provided, even with practitioners who do work such as DUIs saying, what I'll do is I will divide up the value of my representation on all the pretrial work, which is where it really happens in 90% of cases, and I'll do my trials for free. There is nothing that prevents us from doing that or from having an arrangement where one half of the fee is a pure retainer for availability to do the work, so that if the work is canceled the day before we're going to do it, that a pure retainer very well could be a part of determining what that refund is. I think what we need to do is step back and think outside of the box about how we address those issues, and they can fit within this rule. And I say that as somebody who uses these prepaid fees as 90% of my practice. So again, I would ask that you vote in favor and think creatively of how we can use this rule to set a standard for attorneys and also for the benefit of clients. Thank you.
Thank you. With no further discussion, we will proceed to the vote on BOG Resolution number 2. Please give us a moment for staff to ready the vote. Voting is now open. Please turn to the resolutions page of your HOD voting dashboard. Hit the refresh button, then indicate your vote. Yes if you support the resolution, no if you oppose it, and abstain if you prefer not to vote. Again, your vote is final once you submit it. You have 1 minute to vote. Please start the timer. Voting will close in 30 seconds. Voting will close in 5 seconds. Please close the voting. We will now tally the votes. It'll just be one more moment. Okay, the voting results are ready. Please hit the refresh button to see the vote results. The number of yes votes was 127. The number of no votes was 22, and the number of delegates who abstain are 11. This motion passes. Next up is BOG Resolution number 3. General Counsel Ankur Doshi will present the resolution.
Thank you again, Maya, for the introduction. The Board of Governors proposed Resolution number 3 to harmonize the lawyer rules of professional conduct with the introduction of licensed paralegals in Oregon. Licensed paralegals are licensed to provide limited scope legal services in family law and landlord-tenant law. LPs are regulated by the bar and must follow rules like the lawyer RPCs, known as the Rules of Professional Conduct for Licensed Paralegals. Currently, there are 28 licensed paralegals within Oregon, with more expected as the program continues to grow. When the lawyer RPCs were originally adopted in 2005, the RPCs only referenced lawyers as the type of legal practitioners. Because the lawyer RPCs were drafted in a lawyer-only environment, gaps and ambiguities have emerged, particularly in areas regarding communications, conflicts, and firm management provisions that create certain uncertainty in day-to-day practice with regards to licensed paralegals. Recognizing the gaps that have formed between practice with licensed paralegals and lawyers, the Legal Ethics Committee undertook a study of the rules of professional conduct and invited several stakeholders, including licensed paralegals, to review the current rules of professional conduct for lawyers. The LECs studied these provisions for over a year and submitted the following recommendations within BOG Resolution number 3 to the board in June. These amendments update definitions and cross-references so that the core duties, confidentiality, conflicts and imputation, candor to tribunals, trial publicity, supervision, and reporting apply cleanly in matters involving LPs as well as lawyers. Many of these changes are relatively benign to the meaning of the RPCs. However, the Legal Ethics Committee did recognize 2 issues that raised substantial debate and sought to resolve these issues with the stakeholders involved. The initial issue that was raised related to the sharing of fees between lawyers and licensed paralegals of different firms. Lawyers raised concerns about licensed paralegal obtaining clients clearly outside of an LP's practice area and requesting a referral fee to refer the clients to a lawyer. LPs raised concerns that the rules required referral of matter to a lawyer. LPs raised concerns that their rules of practice require the referral of matter to a lawyer when the matter exceeds the scope of practice for an LP, and how that model would function if fee sharing was not allowed under RPC 1.5. After substantial discussion, the LEC determined that the best method of resolving both of these concerns was through language that requires proportionality. This language resolves fee splits between LPs and attorneys in different firms so long as the fee is proportionate to the service provided by each party. This amendment would address concerns about referral fees outside of LC's scope of practice, while ensuring LPs receive fair compensation for their contributions. The amendment does not change the current rule for fee splitting between lawyers. The Legal Ethics Committee also heard substantial concerns about firm structure, supervision, and firm ownership with the involvement of LPs. The LEC considered multiple models of ownership and structure of firms that utilize LPs, including an evaluation of how other jurisdictions utilize LPs within a firm structure. Based on feedback from multiple members, the LEC opted to utilize a new rule that governs ownership rights for LPs within a firm. New Rule 5.8 within the resolution, based off of Washington's corresponding rules in regards to their limited license legal technicians program, allows for limited ownership rights so long as the licensed paralegal does not own a majority stake in the firm and does not directly supervise lawyers. These proposed guardrails prohibit licensed paralegal control or supervision of lawyers and bar interference of a lawyer's professional judgment, while maintaining managing lawyers' responsibilities under the existing supervisory rules. The addition of RPC 5.8 does not expand the scope of an LP's practice area or allow for ownership of a firm by an unlicensed person. These amendments seek to clarify a number of ethical issues that have arisen over the course of the last year when the Oregon State Bar originally introduced licensed paralegal into practice. These issues will continue to happen as the LP program expands. Absent these amendments, lawyers will continue to have ambiguity in their interactions with LPs representing clients. The board urges the House of Delegates to adopt these amendments to the RPCs.
Thank you. Do we have a motion from one of our BOG members? Thank you. Mike Purcell from Region 5 has moved. Thank you. Do we have a second to the motion? And we have a second from John Bachhoffner from who's the out-of-state delegate. Now for discussion, please give staff a moment to prepare the debate queue. The debate queue is ready. If you want to speak on the motion, click the debate queue button, indicate your position and location, and click submit. Okay, I recognize Dean Alterman from the motions questions queue.
Good morning, Dean Alterman, Region 5. I have a question. I noticed in many places wording "a lawyer shall not" was left in, but LP was not added. Oh, for instance, a lawyer shall not, Rule 1.6, a lawyer shall not reveal information relating to the representation of a client. LP wasn't added. A lawyer shall not enter an agreement for an excessive fee. LP wasn't added. Is that intentional, and is there some other rule that's not in the pack that imposes similar obligations on LPs? Thank you.
Yes. To respond to your question, the LPs are not governed by the rules of professional conduct by lawyers. They're governed by the rules of professional conduct for licensed paralegals. So that rule has a similar corollary in their rules. So rules that specifically limit LPs to their fees are written in what's known as the rules of professional conduct for LPs 1.5. So the tricky part about this is there are two sets of rules, one that governs lawyers and one that governs LPs. These amendments specifically deal with interactions by lawyers with LPs, not necessarily rules that govern LPs. Now, the corresponding rules for LPs do have similar rules. They just are slightly different because of the fact that LPs have a limited practice scope, and that's addressed in those rules.
Thank you.
Sorry, my mic was off. With no further discussion, we will proceed to vote on BOG Resolution number 3. Please give staff a moment to ready the vote. Voting is now open. Please turn to the resolutions page of your HOD voting dashboard. Hit the refresh button, indicate your vote. Yes if you support the resolution, no if you oppose it, and abstain if you prefer not to vote. Again, your vote is final once you submit it. You have 1 minute to vote. Please start the timer. Voting will close in 30 seconds. Voting will close in 5 seconds. Please close the voting. We will now tally the votes. Okay, the voting results are ready. Hit the refresh button to see the vote results. The number of yes votes was 138. The number of no votes was 6. And the number of delegates who abstain are 11. The motion passes. Next up is Delegate Resolution number 1, presented by Danny Lang, ex officio member, Region number 3. And he is just getting to the podium now.
Danny Lang, Region 3 ex officio delegate and president of the Douglas County Bar Association. A year ago, there was some debate about the contents of rules regarding providing clothing or minor items to people in need who either were potential clients or they were a client. And I sat and listened to that and didn't participate. But it kind of gnawed on me the rest of the year because I don't want to be one of those greedy lawyers who won't give a damn for the client. So I'm going to use a hypothetical, but I've had this situation more than once, many times. A low-income person, single mom with multiple kids, with a minimum wage job, is a passenger in a vehicle and is injured. And she doesn't have a way now to get to work. She also can't get to the doctor. I do personal injury cases, and then you try and schedule an appointment and say to the reception at the law, well, where is Susie Q? Well, she called in. She doesn't have gas money to go 40 miles to come to the office. I'm not allowed to assist that person financially other than with some used clothing. It isn't going to do any good. Now, today we have this new values that was handed out. And I'm going to shorten my time to item 8 of the updated values, because it talks about valuing compassion means the OSB creates opportunities for different viewpoints and lived experiences, emotions, seeks to understand perspective, and attentively to all constituents. Well, because I couldn't do it, I got creative, and the last one of these hypothetical persons, we'll call it victim A, accident injured victim A. I managed to spend several hours going to a nonprofit who received cars, and they had a car for sale for $600 that ran. I call it the ugly duckling. Most dealers or charities that take cars have a few ugly ducklings around. But I couldn't give her the car, but I persuaded the nonprofit to give her the car. Oh, okay. I hope I didn't violate any rule there. So I think this needs to be loosened up so that random acts of kindness and humanitarianism and benevolence is not unlawful, is not subject to discipline. I happen to, over my lifetime, have had many sins, many faults. But as I age, I've been more and more concerned with my fellow human beings. In fact, when I was 18, I took an oath to give light to those with whom we travel life's pathways. That's one of the reasons I come here, because I enjoy your company and your intellect. So I think we shouldn't have a bad public image of being pecunious and not willing to take care of these people as needed in order to prevent the few violators who would use money as these telethons, late night telethons, if you've seen them, call in and there's a phone bank and tell us if you're not at fault, been injured, we'll tell you in that phone call without meeting you, we'll tell you what your case is worth. Now that goes on. Oh, by the way, our sections, of which I was on the board of the sustainability section and enjoyed that, we're allowed to donate. A section can donate. And when I was on, there was a donation to a underserved community that wanted to hire, it was a law firm that wanted to hire one additional person, and we contributed to that. So it strikes me that here, there, the benevolence is okay, approved. But if it's from the heart and soul of each of you, no, we can't do that. So I'm going to move adoption of delegate rule number 1 and say that it's very consistent with our value and policy number 8, compassion. That's the new basis of my resolution. Thank you.
Thank you, Danny.
By the way, I'm legally deaf, so I'm not able to hear you or most people.
Okay, do we have a second to the motion?
John Schlosser, Region 5.
I believe that was Charles Schlosser. John, sorry. Schlosser, Region 5. Now for discussion, 1 moment while staff prepares the queue, please. The debate queue is now open. If you want to speak on the motion, click the debate queue button, indicate your position and location, and click submit. I recognize Theodore Reuter, who is remote.
Hi, thank you, Theodore Reuter, Region 4. I just want to address kind of the premise of this resolution, which I think is incorrect. If you look at RPC 1.83, it has, excuse me, 1.8E3, it has been modified recently to allow for gifts, modest gifts for food, rent, transportation, medicine, or basic living expenses. And so there are 2 points that I want to make about this. The first is this whole section is only about gifts to clients. So in the same way that bar section can make a general donation to an individual person in need. There's nothing that prevents a lawyer from making a similar gift. But also, we just changed this rule to allow for exactly the kind of gifts that Mr. Lang is talking about. I don't think we should start changing it again until we see how this works. I'm generally not a big fan of changing the RPCs anyway, because we have to figure out how to live with them. So my suggestion is that, well, I think it's a laudable goal, and I think most people in this room would agree that we should try to help people who are less fortunate. The rule already allows for it with respect to clients, and there has never been a prohibition about helping people who are not clients. So I would suggest that it is appropriate to vote no. Thank you.
With no further discussion, we will proceed to the vote on delegate resolution number 1. Please give us a moment for staff to ready the vote. Voting is now open. Please turn to the resolutions page of your HOD voting dashboard, hit the refresh button, and then indicate your vote. Yes, if you support the resolution, no if you oppose it, and abstain if you prefer not to vote. You have 1 minute to vote. Please start the timer. Voting will close in 30 seconds. Voting will close in 5 seconds. Please close the voting. We will now tally the votes. Okay, the voting results are ready. Hit the refresh button to see the vote results. The number of yes votes was 44. The number of no votes was 95 and 20 abstentions. So the motion fails. Next up is delegate resolution number 2. Here to present the resolution is Danny Lang, ex officio member from HOD Region 3.
Danny Lang, ex officio delegate, Region 3, president of the Douglas County Bar Association. A few minutes ago, I included the phrase or words infomercial, late night infomercial. Well, perhaps this resolution could be viewed that way. I'm going to give a little quick history to commend the Oregon State Bar. Back around 2007 or 8, they created the OSB Leadership College. I was very blessed to be selected as in that first class. I was the oldest fellow, still am. And I then was on the board. And my final year, I was chair of the Leadership College Advisory Board. During that year, we were able to focus on many issues. One of the big ones was addressing poverty. And we had all-day CLE credited programs. One of them was at the women's prison not far from here. In the morning, we had 4 women give their stories. very heartbreaking, very interesting. And recidivism was running 50% because they can't get a job because they've got a tattoo now that says felon. And how you deal with those things. The interesting statistic came out from prison staff that the cost then was $30,000 per year to house an inmate. And one of those 4 young women had a child, an infant, and the state paid $13,000 a year for that. All added up, we figured that to incarcerate someone for a period of 6 or so years equals the amount of tuition could have been paid to Harvard University and room and board. So we looked at those issues. It was stimulating. We didn't solve them or don't solve them, but we use it as a catalyst. One of the other programs that we did in Roseburg, we went to the Roseburg Mission, and we spent the morning with the problems faced by what are now called homeless people. These were people who were struggling with life because of physical disabilities, injuries, mental health, family problems, disease, and how society addresses them and how they impact and cost everyone else some disadvantages. There's an impact, cause an impact on us. So I was pleased to hear that although the Leadership College was abandoned somewhere around 2011, they now have the Leadership Institute. And I'm trying to couple that with a resolution that I got passed by this body called in greater engagement with HOD members, because I am still a little bit mystified. We don't live in a perfect world. The legal profession isn't perfect. The justice system isn't perfect. And why aren't there more people up here with resolutions, right or wrong, trying to address some of these issues? So I think the practical benefit here is that if we, just as a matter of these updated values, if we could integrate the people that have been selected for the Leadership Institute to have some of their sessions integrate with volunteer HUD members. I'll be happy to volunteer. I'm sure there's several of you here that would like to volunteer and share our experiences practicing law and with the courts and the justice system and the legislature and some of those issues. So my infomercial's about over, and I would like you to vote in favor of simply considering some coordination and combining of these 2 excellent functions, the HOD and the Leadership Institute, because the Leadership Institute, following the Leadership College, was designed to grow leaders for the bar. Well, you're leaders, you're here. And so I so move for adoption of Delegate Resolution number 2.
Thank you. Do we have a second to the motion?
Second, Mike Purcell, Region 5.
Okay, Mike Purcell, Region 5 has seconded the motion. Now for discussion. The debate queue is now open. If you want to speak on the motion, please click the debate queue button, indicate your position and location, and click submit. Okay, with no further discussion, we will proceed to the vote on Delegate Resolution number 2. Please give us a moment for staff to ready the vote. Voting is now open. Please turn to the resolutions page of your HOD voting dashboard. Hit the refresh button, indicate your vote. Yes if you support the resolution, no if you oppose it, and abstain if you prefer not to vote. You have 1 minute to vote. Please start the timer. Voting will close in 30 seconds. Voting will close in 5 seconds. Please close the voting. We will now tally the votes. The voting results are ready. Please hit the refresh button to see the voting results. The number of yes votes was 84. The number of no votes was 45. And the number of delegates who abstain are 22. This motion passes. Next up is delegate resolution number 3. Here to present the resolution is Danny Lang, ex officio member from HOD Region 3.
Danny Lang, Region 3 ex officio delegate, president of the Douglas County Bar Association. Okay, by the way, thank you for passage of the last resolution I presented. This one comes out of some things that happened at this meeting last year. Going back the year before last year, with the implementation of licensed paralegals, there was a resolution that I launched or presented, and to my recollection, what the gist of it was to broaden the scope of paralegals, because presently, although it's unknown to many folks, including many lawyers, they're only allowed to practice in 2 areas: landlord-tenant and family law, and they're not allowed to do contested hearings. They are more of an advisory function, explaining forms, explaining rights to people. None of them that I know of have ever been able to successfully go out alone as be a solo practitioner or go into unserved communities and have a legal clinic. No, they're winding up in law firms. We have a licensed paralegal in Douglas County, and in law firms that are able to bill more, ironically, by having one of them on board to meet with clients.
I think you're talking about resolution 4 instead of 3.
Oh,
I think you may have skipped ahead.
well, okay. I was getting, I apologize. Thank you. But what happened last year, to make it relevant, was that when we went to broaden it, well, I'm still on the infomercial. When we went to broaden it, just ahead of it, there was concern that this might cost unbudgeted money and staff time. It might even be up to $30,000. That chill took the original vote, I believe it was 126 to 12 in favor of broadening the paralegals so they can meet these unmet needs, to a reversal of the numbers, because our dues are already reportedly the highest in the country. And if there's no budget for this, well, then the fear of yet another rate hike put a chill. And you know, I enjoy doing this. I really enjoy being a lawyer. But I find that I've spent about 7 full days preparing for these 4-hour presentations. And all of you are here. You're all volunteers, and the bar's paying mileage for you to travel here and have bar staff here. Yet the resolutions that we adopt, until this year, they tend to go in a file cabinet from my perspective. There's no follow-up by the HOD. So that was the part of the HOD engagement. And there's no pre-hearing. There are a few call in. I'll go back to my favorite words, infomercial, where people can call in and ask questions or be prepped as to what we'd be speaking about here. But if we're this resolution really calls into question, what's the function? What's our function? I know there's statutory requirements, things that we do, that we must do. But why not use the talent that's behind the faces that I'm looking at here and our other 16,000 brothers and sisters and provide adequate funding for the body of representatives that will advise the Board of Governors on things that needed to be improved? Better access to justice, addressing declining enrollment in law schools, declining bar membership. So I just think that if we treat the HOD, treat all of us here in a sense marginalized, that, well, we're not going to put any money aside. We're going to let you come in here and let Danny Lang talk to you, and then we'll all go home, and so be it. I think we need to invigorate, and I don't think that you can do it if there's a chill that, well, this might cost some unbudgeted money. So that's why I want allocation. I'm going to move adoption of Delegate Resolution number 3. That did come back to being relevant. Thank you.
Thank
Okay.
you.
Okay, thank
Do
you.
we have a second to the motion?
District 5, second.
And that was Mike Purcell, District 5, that seconded the motion. Now for discussion, 1 moment while staff prepares the queue. The debate queue is now open. If you want to speak on the motion, click the debate queue button, indicate your position and location, and click submit. Okay, with no further discussion, we will proceed to the vote on Delegate Resolution number 3. Please give us a moment for staff to ready the vote. Voting is now open. Please turn to the resolutions page of your HOD voting dashboard, hit the refresh button, then indicate your vote. Yes, if you support the resolution, no if you oppose it, and abstain if you prefer not to vote. You have 1 minute to vote. Please start the timer. Voting will close in 30 seconds. Voting will close in 5 seconds. Please close the voting. We will now tally the votes. The voting results are ready. Hit the refresh button to see the vote results. The number of yes votes was 28. The number of no votes was 86. The number of delegates who abstain are 40. The motion fails. Next up is Delegate Resolution number 4, presented by Danny Lang, ex officio member, Region 3.
Danny Lang, Region 3 ex officio delegate, President of Douglas County Bar Association. Well, I'm going to adopt a nickname here of Nostradamus. And why is that? Because I'm going to predict that the naysayers will vote this down. Well, what is this? Yeah, I mean it. It's a change. Okay. And so being one of the champions, I created the paralegal program in Douglas County at Umpqua Community College, starting in 2002, and we opened in 2007 and 8 with 75 students instead of the expected 15, the hope for. The program continues. The graduates are throughout the courthouses, insurance companies, banks, real estate agencies. Okay. But licensed paralegals, as I alluded to earlier, are only allowed to advise people, essentially, and attend perhaps mediations in landlord-tenant cases, not try them. And yet, so they can't earn a living. They can't be independent. We can't address unserved communities within the communities and so on. Okay. So given that this body approved licensures of paralegals, we have paralegals out here with very limited hobbled, and we have all of us brothers and sisters here that are full-fledged licensee attorney bar members. There's still that gap. There's still that 80%. You know, that number just won't go down, doesn't seem to go down. So what about, and what about looking at this new policy number 9, updated organizational values? Number 9, innovation is embracing novel approaches without being bound by tradition, with a willingness to make and learn from mistakes. What are we going to do about that 80%? To the naysayers, I say, come on up here. Tell us, give us some alternatives. My alternative in this resolution is that we look forward to creating licensed law practitioners like the medical profession. I don't get to go see a brain surgeon, although some of you think that's needed. Nonetheless, I have to go to a primary care doctor. Well, we don't have primary care lawyers. Well, maybe we do, but I won't go there. So all of us have to have a 4-year degree or 3-year degree, pass the bar exam, incur $300,000 or more in student debt, and so forth. And yet somebody comes in the office and they got a traffic ticket and they're worried about it affecting their job, happen to drive for Amazon or whatever, and it's 45 and a 35. You know, I think a licensed law practitioner, frankly, a paralegal might work, but that's been ruled out. And so was outvoted or voted down the idea of having Oregon State Bar law schools, as California has successfully done for 35, 40 years. Okay. The 3 law schools were opposed to that. I'm saying, well, then let them come forward with a 6-month curricula, maybe a year, maybe 6 months of internship coupled with 2 or 3 month terms of substantive law. And then we can test them or evaluate them or have them be mentored. But somehow or other, we create licensed legal practitioners. Now to the naysayers, have at it. Why am I doing this? Because I'm 85, but I'm not quitting yet. And I'm still planting acorns, little acorns. And you know, a few of those acorns I've planted over the years, they're sprouting. And a couple of them are saplings.
Danny, you're almost out of
I move adoption of Delegate Resolution number 4 before I forget what it is.
Thank you.
Thank you.
Do we have a second to the motion? Okay, Mike Purcell, Region 5. Thank you for that second. Now for discussion. The debate queue is now open. If you want to speak on the motion, click the debate queue button, indicate your position and location, and click submit. And I recognize Christopher Larson, who's in person in the con list.
Good morning, everybody. Chris Larson, Region 5. Just a few comments. I've been on the HOD for, I think, 7 terms, and I just got elected to the BOG. Thank you. These studying ideas, the problem with this is that it calls for study, and study takes time, money, and focus. I'm aware that this is a fairly new program. Right now, it's just not the time. We need to give it a little bit more time to see how things work out with this new program. I've been told our bar dues just increased about 18.3% for practitioners making over $48,725, increased 22.6% for those making under $48,725 a year, and up to a 50% increase for active pro bono, inactive, and retired practitioners. We don't need any more programs costing the bar additional money at this time. Effective feasible studies cost money and time. I'd urge you to vote this resolution down with all respect to Nostradamus over there.
I now recognize David Wade in the pro column.
Hi, David Wade, elected delegate, Region 2, actual Region 2, Lane County. Thank you. I would like to correct the last speaker. The last license fee increase was 5.5 years ago. It wasn't just done. I want to congratulate the Oregon State Bar staff for keeping us on track 5.5 years with no license fee increase. Second, I was opposed to this motion coming in, but then our Budget and Finance Chair showed a very disturbing chart which has new law school graduates coming into the bar are now falling below retirement, which means we're not replacing ourselves. This is very serious. It's very serious, one, financially to the bar, right? Can we still do bar books? For how much longer? And second, it's really bad for the public because now it's going to be even harder to get a lawyer. So it doesn't cost much money to do these kinds of work. I mean, all the BOG members are volunteers. They're not paid any more to study this, and they're paid to study anything else. So I've changed my opinion,
and I'm now in favor of this motion. I realize we've only had licensed paralegals for a few years, but I think we don't have time to wait. And it's possible that we would have more licensed paralegals if we allowed them to have a greater scope. Thank you.
Thank you. I recognize Rachel Phillips from the con queue, who is remote.
One sec, let me turn my camera on. Where is it? And I apologize, I can't seem to get my, there we go. Hi there. My name's Rachel Phillips. I'm in District 5 or Section 5, Region 5, and I'm a criminal defense attorney. I've got roughly 20 years experience, 8.5 as a public defender. And I am against this because criminal defense is so incredibly difficult work. And as we have changes in technology, we have to do like phone forensics, we have to watch hours of body camera footage. The more digital we become, the more work there actually is. And while, yes, there is a shortage of representation for criminal defendants accused of crime, the way forward should not be allowing individuals who haven't gone to law school, who don't have the training, and while they have a different type of training, to take on, even misdemeanors have become more complex and time consuming, to take on cases they aren't trained for, that are incredibly difficult, that have extensive consequences in terms of a criminal record and time in custody. The way forward through this crisis needs to be recognized as actually paying public defenders the money they're worth and comparable to prosecutors and comparable to the attorneys at the DOJ, and not just getting bodies that you can pay, that with less training, that you can pay less money to sort of plug in the gaps and plead all these guilty people out. And I don't think that was the intent behind this amendment, but that's certainly how it could be perceived. And I just don't think the training is there for criminal defense cases. And so I'm a vote no. Thank you.
Thank you. I recognize Michael Purcell, who's in person from the motions questions queue.
You have to get in a queue.
You have to get in the queue. You have to get in the queue, Danny. Go ahead, Mike, you may continue.
Real briefly, maybe Ankur could address this. Again, I survived 3 years of legal ethics committee, and this stuff, said I say survive, experienced. This issue came up, was quite a bit, it was reviewed in the rules for professional non-practice. Oh yeah, Michael Purcell, Region 5. And I wonder, where does a proposal to expand it, where does that go, Ankur? What's the procedure for that? And also, can you address, if possible, the current education requirements for people that are now participating? If I remember correctly, they're actually quite high. And the understanding that I got was that the people that had training in the areas of landlord-tenant, for example, were going to be much more better trained than the lawyers involved in that. So I don't know.
Yeah, I mean, Michael, briefly with the LP program itself, the requirements for that are, yeah, you're putting me on the spot with the rules here, so that's always a tricky part. Generally, there's a number of ways to qualify for it. There's ones who have had a substantial amount of training in LP programs. I believe that's around 3,000 hours or so. But in addition to that, they could also get a paralegal certification course, which is the general 2-year course that allows it. There's an equivalency program if they do participate in something equivalent to paralegal studies in the military, as well as a requirement specifically within that practice area of landlord-tenant or family law, equivalent to, I believe, about 500 hours in family law or 250 hours in landlord-tenant. This is in addition to a number of other requirements for admission, including a portfolio examination, as well as testing on the scope of practice rules. So there are a number of specific requirements in addition to that, in addition to just doing the test to become an LP, that do require substantial equivalent experience in doing paralegal, whereas it doesn't necessarily just automatically open up the availability of the paralegal licensure to anyone who is readily available to do it. If this resolution moved forward, I think it would be first studied. There would need to be some sort of mechanism to place it in. That would be something that would be determined by the studying group at that time. If, for instance, with the licensed paralegals, that was created through a separate set of rules that was approved by the Supreme Court, the rules for licensing paralegals. If it eventually approached there, it would do something along those lines. And Helen, if you wanted to say anything. It'd be pretty premature right now to say where exactly would fit, but it would be something along those lines.
I recognize Ryan Jennings, who is remote from the con queue.
Hi, Ryan Jennings, Region 6. I just kind of wanted to put some context on what programs look like because I had no idea until I was on several committees over the last several years. But the current LP program was really launched in earnest, as I understand it, in the Futures Committee in 2017. I wasn't on that. I was on the Paralegal Licensing Implementation Committee for what seemed like several years. There were rules that had to be developed, pathways to getting the certifications, what requirements, so many decisions had to be made and discussed. It wasn't actually adopted by the bar, I don't think, until 2023, launched in 2024. And just today, we're finally passing the rules so that lawyers and licensed paralegals know how to work with each other. 2 years in, oddly. It can't be understated or underestimated how much work went into it from the bar, and dozens, if not 100. I don't even know how many volunteer lawyers worked on it in multiple committees. And I'm on the LEC, and that took a long time to develop the rules that we all voted on just this morning. It is still young. As Ankur said, there's only 28 so far. Starting that over again, and the amount of work and resources that would go into it can't be understated. And we don't even know if the current program is going to meet the goals that it was stated to try to address, or maybe some of the ones that Mr. Lang, who I think is extremely well-intentioned, and I'm not trying to argue with him or make him feel like Nostradamus, but it is a whole lot of work, and we don't even know if the program that we just launched is going to accomplish any goals that it's intending to. And so I'm a no vote.
Okay, thank you. I now recognize Elizabeth Inayoshi, who's here in person.
Elizabeth Inayoshi, Board of Governors, Governor for, and I will say the proper region this time, Region 4, which I didn't last time. I kind of have a question, which potentially could lead to a motion. We don't have, do we, any kind of standing group, department, committee within the bar right now for looking at these new methods? Do we? We've generally put them together as standalone activities, somebody to do the licensed paralegal, another group to do the SPPE. I'm not mistaken in that, am I?
That's correct, Elizabeth.
We come back to this question often in these HOD meetings. And it's true, I do think we're premature on trying to do something right now because it needs a lot of work. But perhaps what we should be looking at is more of a standing group, a long-term group that continues to look at different ways to approach the problem that we have with having insufficient practitioners. And I don't know if that's, a standing committee or what, but, I would not vote for this particular motion simply because it's a little too vague in terms of consider this. But I would like us to look at doing something more specific. And I don't know how I make a motion for a friendly amendment, if you will. But I would like to do that, to say, maybe what we do is make a motion to have a standing committee to look at these kind of things.
That's a pretty huge amendment to this, and I'm not sure whether that would be in order.
Okay.
Probably not,
Probably.
is what we're hearing from our parliamentarian.
That's fine.
Okay, we have confirmed that that is out of order. I now recognize Daniel Lang in the pro column, who is in person, and will be walking up to the queue now for the pro queue.
Danny Lang, Region 3, ex officio delegate, President of Douglas County Bar Association. Oregon's on the forefront in a lot of things. Like it or not, assisted suicide, reform of drug laws. Paralegals. Back in 2002, when I proposed that, no. And all the way through the next decade, no. Until Washington State did it, Wyoming did it, and 22 other states are developing licensed paralegals. Then we said, okay, let's do this. So I'm not saying start this now. I'm not saying spend a lot of money on it now. I'm literally planting the acorn because I think sooner or later there's got to be, for example, there are 192 administrative agencies in which people from the bottom 50% of our society in wealth and income need to appear. Their lives are affected by those agencies. And they can't always afford, or that bottom half plain can't afford us. But they might be able to afford somebody who's qualified enough to handle an implied consent hearing or whatever, a planning, a land use, the list goes on, an employment hearing, especially trained in it. They get a certificate of competency in that area, and they charge $80 to $120 an hour, and they're not on our turf. They're not taking away any of our bread and butter. How many times you get a phone call and you say, I'm sorry, we'll have to, we might have a conflict of interest. Well, I think the conflict of interest is our rates are too high. Do we exist to better ourselves financially and forget about the 80% that's been ignored, that hasn't been addressed? So this is yet another step that I'm trying to plant the seed, and I don't expect it to pass. But I've stimulated some minds, I hope, to start thinking ahead, like, well, maybe we really, really need to take some creative, innovative action, like the new guidelines say, innovation, and at least talk about it. Make it a discussion agenda item at a future HOD meeting, instead of just having a set agenda with rigid items and rigid actions. Round tables, or before the meeting or after the meeting, round table discussions as to where we're going. We're the representative body. The Board of Governors is more like the Senate. We're not getting it done yet. Maybe we need to be innovative and just consider, that's all I'm saying, adopt this so that in the future, somewhere in the future, Oregon can be on record of, well, yeah, in 2025, they voted to
Danny,
consider.
Your time
Just
is up.
think about, consider licensed law practitioners. And thank you for your patience today.
Thank you. I now recognize Don Winalski from the motions questions queue, who is remote.
Audio. There we go. Hello. Turn my video on.
We can hear you.
Okay, cool. Hi, Dawn Winalski. I'm in Portland. I'm representing the Indian law section. I just have a question that's kind of similar to what Elizabeth brought up of just like if we're hearing, let's not try a new program because this other one just came into effect last year. Are there studies and reports that are already planned to be done so that we do know if that new program's been effective, how many people it's reached, how it's growing year over year, such that in 2 years from now or whenever something like this comes up again, we can make a better decision?
This is Helen Hirschspiel, the CEO of the Oregon State Bar, and I'll attempt to answer your question, Dawn. We are almost completed. We are close to completing a access to justice gap analysis. The report will be presented to the Board of Governors at its November meeting. One of the issues that we looked at in that gap analysis is how are licensed paralegals being used? Where are they? How many are there? And whether there are additional opportunities for expanding their use specifically. So we're doing that work, yes. And then also we are regularly publishing what we call our measuring impact report, where we talk about, again, those same types of measures about effectiveness of the various programs of the Oregon State Bar. So I think the answer to your question is yes. The other thing that I would note, and this is sort of along the lines of what Elizabeth was saying, and I think maybe speaks to kind of a broader question, which is the access to justice crisis, problem, persistence of that is very much on the minds of the Board of Governors. And it is a big part of the strategic plan that the board will be adopting in November. So we're not ignoring the issue. The board is doing a lot to try to address it.
Thank you. And then can I just add a follow-up? I think some of the other motions today have related, and this one have related to kind of communications. I think as chair of a section, this is my first touch point with the House of Delegates. I didn't know what I was even showing up for today. And so if there's better ways to share those reports and stuff, maybe directly to the sections or something as it comes up, that would be really useful.
Okay, thank you. I now recognize Rafe Newman from the ProQ, who is in person.
Hello, Rafe Newman, Region 5, ex officio, I think, as the chair of the Solo and Small Firms Committee. I'll acknowledge that my support here is ambivalent. I do think that the resolution is vague, but given some of the other comments, the fact that it took 6 years to get the program as it is through, another 2 to conform and start to look at it. I agree with Danny that we shouldn't be waiting, and I don't know if the report coming out is sufficient. But I guess part of my ambivalence is I'm tempted to vote yes, so that we have some vehicle for considering these issues immediately, and continuing to consider them, following on Elizabeth's suggestion of a standing committee. This might be imperfect, but it might be what we have. And so there's my ambivalent support. Thank you.
Thank you. I now recognize Simone Wyand from the con queue.
Simone Wyenbog, Region 4. While I think this resolution has a lot of good intention, the reality is I have worked in public defense. I've worked as a DOJ attorney. I've worked as a prosecutor. I currently handle admin cases. When you look at things like Resolution 5, which is coming up later, and when you hear the testimony or comments from a public defender, what brings to mind to me is these are things that need to be addressed. We need to fund public defense services and we need to fund legal aid. In my experience with administrations, agencies, and legislatures, if you give them something to sort of go off on a sideline, they'll take it. If we as a group say, you know what, you're not funding our legal aid, we're not funding our public defenders, SB, but maybe we can do this other thing over here. It gives them an out. And I think that while it's well-intentioned, we need to say to each other as attorneys that we need to fund the programs that we know work for low-income individuals in this state, and we need to push hard on it. We don't need to give them any thought that there's some other vehicle other than full funding. So as this is on this resolution, I really urge everyone to look at Resolution 5 because I do think that it addresses many of the concerns. So I ask that you vote no.
Thank you. I recognize Shay Meehan from the motions questions queue.
I appreciate the work that's been done on this resolution. I'm just wondering, is there anything that would prevent the Board of Governors from implementing the kind of standing committee that Ms. Inayoshi has discussed as the response to this resolution?
Would there be anything that would prohibit the board from doing that?
Well, yes, and as a direct response to this resolution asks that this issue be studied. It doesn't necessarily prevent implementation of Elizabeth's proposal as the way to implement that study. And so I'm just wondering if even without an amendment, that might not be a way forward. And I suppose I say that with the same idea of maybe planting a seed in light of the years that it takes to make change.
So I think the board could establish a standing committee to study innovative ideas to address access to justice. Certainly, I think that could happen. The concern about changing this particular resolution to be that is that, I mean, that raises a whole nother set of questions, and I think we would have provided a financial impact on something like that.
But my question isn't about changing the resolution. My question is, without any change to this resolution, can the BOG's response be formation of this committee?
It is possible.
I recognize David Wade from the Pro queue.
David Wade again, Region 2. It's a lovely thought to increase legal aid funding and public defense funding, but if I'm not mistaken, I think about 44% of legal aid funding comes from the federal government, and they're just about to cut it in half. So don't think that you can avoid this question because some miracle worker is going to come in and hand the state of Oregon replacement for these federal dollars. It isn't going to happen.
Thank you. With no further discussion, we will proceed to the vote on delegate resolution number 4. Please give us a moment for staff to ready the vote. Voting is now open. Please turn to the resolutions page of your HOD voting dashboard. Hit the refresh button, then indicate your vote. Yes if you support the resolution, no if you oppose it, and abstain if you prefer not to vote. You have 1 minute to vote. Please start the timer. Voting will close in less than 30 seconds. Voting will close in about 5 seconds. Please close the voting. We will now tally the votes. The voting results are ready. Hit the refresh button to see the vote results. The number of yes votes was 42. The number of no votes was 109. And the number of delegates who abstain are 7. The motion fails. Next up is delegate resolution number 5, presented by Peter Werner from HOD Region 1, Christy Gibson from HOD Region 2, Victory Walker from HOD Region 3, Sonia Montalbano from HOD Region 5, Vanessa Nordig from HOD Region 6, and Heather Decker, HOD Region 7.
Hello, I'm here representing Region 7 as a delegate and presenting the HOD Resolution number 5 today in support of adequate funding for civil legal services for low-income Oregonians.
Heather, can you state your name too?
Yes, Heather Decker. And President Kehoe just listed the other delegates who are also supporting and presenting this with me. And they're all joining me today because we recognize the growing need for support for legal aid. Legal aid is the statewide network of providers of free civil legal help for those who can't afford a lawyer and serves the lowest income population in this state. In order to qualify for help, a client has to make under $20,000 a year. Even with that eligibility cutoff, legal aid is still overwhelmed with requests for help that they have to turn away. And it's only able to serve currently 16% of low-income Oregonians' legal needs. And this means that critical services must be prioritized. In 2024, legal helped almost 2,000 domestic violence survivors and almost 4,000 people either stay in their homes or make a transition to more stable housing last year. With our help, legal aid can do more. I support the Campaign for Equal Justice. the legal aid's statewide support organization. And we should all support this resolution because it helps us fulfill the Oregon State Bar's mission to serve justice and the public interest by promoting respect for the rule of law, by improving the quality of legal services, and by increasing access to justice. As bar leaders, we set the example for bar licensees and should fully support this resolution. As lawyers, we have a professional obligation to work to ensure access to justice for all segments of society. This resolution increases access to justice for low-income Oregonians. Litigants with legal representation make courtrooms run more smoothly and efficiently. And studies show that when we have access to a lawyer, we have greater faith in the justice system. I urge us all to vote yes on this delegate resolution and also urge delegates to contribute to the campaign for equal justice. Our goal in the HOD is a 100% participation rate from representatives who serve in the HOD for CEJ giving. And if that means $5 from you, that is great. We would appreciate it. Participation numbers are very important for the CEJ to fulfill its mission and give a strong participation rate of bar leadership at any level of giving, and also encourages others to give. To donate online, you can go to the CEJ website at cej-oregon.org. In closing, please support this resolution. Thank you all for being here today.
Heather, you didn't move for the motion.
It wasn't in my script.
You'll need to move for the resolution.
I move to adopt Resolution 5 in support of the Campaign for Legal Justice and low-income Oregonian legal services.
Thank you. And I believe Danny Lang from Region 3, ex officio delegate, has seconded the motion.
Can I go sit down?
Yes. Now for discussion. The debate queue is open. If you want to speak on the motion, click the debate queue button, indicate your position and location, and click submit. I recognize Lauren Grace from the pro queue.
Good morning, Lauren Grace from Region 6. I am a staff attorney at the Oregon Law Center. The views here are my own and not those of my organization. I just want to say, like last year, thank you to everyone who has worked on this, and just add a little more perspective from as a staff member. This is particularly important this year, given the funding situation that we've sort of alluded to this morning. And again, this is not officially, this is just the perception and the vibes of the staff, the grapevine we've been getting on what it is. And that matters because we often, under ordinary circumstances, feel significant financial pressure in order to do the work we do based on the salary level. I personally did not know just how expensive childcare is. But then when you add on this current crisis and the anxiety about whether our jobs are even going to exist, it makes it that much harder for us to continue to do our best work for our clients, which is what they deserve and what they need more than ever in this current situation we're in. So thank you, and please vote yes.
Thank you. I recognize John Schlosser, who is in person from the con queue.
John Schlosser, Region 5, and I'm not actually here in the con. There's no con to this. If you vote against this, you should just be ashamed of yourselves.
Okay, thank you. Stephen Raher? Rare? Thank you.
Thank you, Stephen Rare, ex officio member as chair of the Debtor Creditor Executive Committee. Given the amount of work that's gone into this, I'm not foolish enough to propose an amendment, and I've supported the Campaign for Equal Justice since my first year out of law school, so I thoroughly support it. My only reason for speaking is the provision, the goals in paragraph 4 states 75% target for section contributions. Just as a matter of implementation, when you do that tally, I would like our section, the debtor creditor section, I think should get credit. Just based on financial reality, we do not have a budget for donations, but 10% of our budget for 26 is direct financial support of a pro bono clinic that is a joint program between our section and Legal Aid Services of Oregon. So I don't know how many other sections provide that direct support, but I would encourage the bean counters to give us credit despite the general ledger code that we use. Thank you.
Okay, with no further discussion, we will, oh, sorry.
Vanessa Nordyke, Region 6, HOD Delegate. I too will be expressing my full support for this resolution. There is a huge need for support for our lower income Oregonians. And if you know, based on the federal shutdown, SNAP benefit cuts are coming, Medicaid cuts are coming. As someone who's transitioned from public law to serving a nonprofit in juvenile justice, Casa Marion County, I can tell you how severe these cuts will be felt by some of our most vulnerable children and families. And I would also like to encourage all of my fellow delegates from Region 6 to join us for the Campaign for Equal Justice annual fundraiser. That will be Thursday, November 13th in Salem. And please go to the CEJ website to find out about fundraising opportunities in your neck of the woods. Thank you, and I will be voting yes.
With no further discussion, we will proceed to the vote on delegate resolution number 5. Please give us a moment for staff to ready the vote. Voting is open. Please turn to the resolutions page of your HOD voting dashboard. Hit the refresh button, then indicate your vote. Yes if you support the resolution, no if you oppose it, and abstain if you prefer not to vote. You have 1 minute to vote. Please start the timer. Voting will be closing in less than 30 seconds. Voting will close in 5 seconds. Please close the voting. We will now tally the votes. The voting results are ready. Hit the refresh button to see the vote results. The number of yes votes was 143, the number of no votes was 3, and the number of delegates who abstain is 10. This motion passes. Next up is delegate resolution number 6, presented by Vanessa Nordyke, delegate from HOD Region 6.
Good morning, fellow members of the Oregon State Bar. My name is Vanessa Nordyke, House of Delegates Region 6 and Oregon State Bar President for the year 2018. I am pleased to carry House Delegate Resolution 6 today to support adequate funding for our judicial branch. The objectives of the Oregon Judicial Branch align with the bar's mission to promote respect for the rule of law, improve the quality of legal services, and increase access to justice. This body has regularly approved similar resolutions in the past, and I want to briefly touch on why it is so important that we continue to do so. The Oregon Judicial Branch has adopted a robust justice campaign for 2024 through 2027, which continues 4 key commitments to the people of Oregon. 1, to collaborate with partners to improve services and access. 2, to improve the court user experience by identifying and eliminating barriers to access to justice. 3, to earn the public's trust and confidence. And 4, to provide a workplace and courthouse culture that is welcoming to all. The Chief Justice has passed her budget request on needs flowing from the agency's strategic planning process, prioritizing these commitments. The OJD will need adequate resources to fully invest in facilities, staffing, resources, outreach, training, and quality services to all Oregonians. We thank the Oregon Legislative Assembly for its commitment to Oregon's courts and for its support of the Oregon Judicial Department's Justice Campaign. We request that the Assembly continue to approve funding to provide necessary court services, improve compensation to attract and retain highly qualified judges, and provide safe and secure facilities. I can tell you, as someone who has practiced law and been to courthouses around the state, the security of many courthouses is pretty lax. Pretty lackadaisical. In some places, that courthouse security is a sticky front door. That is it. We can do better, folks. We can do better. We have to provide safety at these courthouse facilities. I urge all members of the bar to thank legislators for funding the judicial branch and to urge their support for the Chief Justice's recommended budget. The bar has a longstanding and close relationship with the Oregon courts, and I ask this body, my peers, to enthusiastically support Delegate Resolution number 6. I hereby move Resolution number 6.
Thank you. Do we have a second to the motion? Okay, I recognize Leanne Donaldson from Region 5. And she has seconded the motion. Now for a discussion. Wait for staff to confirm the debate queue. Okay, the debate queue is now open. If you want to speak on the motion, click the debate queue button, indicate your position and location, and click submit. With no further discussion, we will proceed to the vote on Delegate Resolution number 6. Please give us a moment for staff to ready the vote. Voting is open. Please turn to the resolutions page of your HOD voting dashboard, hit the refresh button, then indicate your vote. Yes, if you support the resolution, no if you oppose it, and abstain if you prefer not to vote. You have 1 minute to vote. Please start the timer. Voting will close in 30 seconds. Voting will close in 5 seconds. Please close the voting. We will now tally the votes. The voting results are ready. Hit the refresh button to see the vote results. The number of yes votes was 143. The number of no votes was 1, and the number of delegates who abstain are 0. The motion passes. The final meeting item, BOG Resolution number 4, is our annual in memoriam, which will not include a vote of the House. Joining me for this item are board members Eddie Passadore, Kyle Schicchetti, and Simone Wyand. Everyone, please stand.
Thank you. The Honorable Lynn E. Ashcroft, Ernest H. Badu, Peter L. Barnheisel, Catherine L. Beck-Fay, Hunter Bittner II, Bruce A. Botany, Robert J. Bazow, Thomas W. Brown, Neva T. Campbell, F. J. Caparati III, Charles W. Carneys, Lawrence A. Castle, David P. Cooper, James R. Cowan, Stuart J. Cutler, E. Joseph Dean, Thomas J. Ditton, Kelly Michael Doyle, Martin Droback, Patrick M. Ebbett, Dirk Edwards, David A. Ernst, Lawrence Evans, Dale F. Evans, Robert N. Funk.
Morris J. Galen, Vernon D. Gleaves, William N. Gross, John L. Henderson, Albert W. Hogue, Michael A. Holston, former Oregon State Bar Board of Governors member, my former law partner, Doug G. Hauser, Susan Gale Howe, John G. Humphrey, Neil W. Jackson, Louise Jane, the Honorable Robert E. Jones, Masha A. Kazakova, John P. Neeland, James J. Kolstoy, Patrick Levis, Stephen R. Ledoux, Thomas J. Lakis, Martin Leuenberger, Robert W. Lockwood, Jan Londahl, the Honorable Malcolm F. Marsh, Philip R. McConville, Terrence K. McGee, Emil O. Muse, Jr., Robert K. Nasland.
K. William O'Connor, Nathan R. Pliska, Christopher Prescott, Michael V. Reed, Monique Renner, Ronald E. Rhodes, Joe B. Richards, Robert C. Robertson, Michael E. Rose,
Douglas A. Schoen, Douglas R. Schultz, Malcolm H. Scott, Edward E. Seitz, Larry N. Sokol, Leslie N. Spitz, Celeste M. Straight, Pamela McCarroll Tees, Honorable Pierre Van Rieselberg, Dennis R. Bavrovsky, David T. Vicola, Melissa J. Ward, Peter O. Watts, Frank S. Wesson, William G. Wheatley, Kenneth A. Wright, Thomas E. Wirtz, Shane Choi Young.
Are there any submissions from the floor? I ask that you all join me in a moment of silence to honor our departed colleagues. Thank you, Eddie, Kyle, and Simone, members of the House of Delegates, and guests. You may be seated. That concludes our business for 2025. Thank you all for participating. This is one of my final actions as the president of the Oregon State Bar. It has been my great honor to serve in this role, made all the more purposeful because of this community of legal professionals so dedicated to a diverse and vibrant bar to serve all Oregonians. Thank you, everyone. And lunch is right outside in the back here, ready to eat. Thank you.